Ms. Rockwell?
Judge.
Don't we have Mr. Easter applicants that you already signed the indictment?
No. Where's
Rockwell,
the,
you're one of the most respected lawyers down here. And you can't let the facts get in the way.
Yes, sir. Thank you.
Right?
who has the indictment?
I do.
Oh.
I was gonna, this lady sign it.
Don't thank you. Calendar is up there.
I see.
Um,
All right, so we've got a plea. Let's come to the podium. Is the state gonna drop the recidivist notice?
For purposes of the plea, Your Honor.
All right, let's go to the podium and let's perfect the record and let's take the plea.
Oh, if you need, okay.
Sign there. Oh, you want to sign there and I'll sign there?
Yeah, that's fine.
You may proceed as you wish.
Mr. Easter, can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And sir, can you please state your true, correct, and legal name?
My name Easter.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you would normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
31 and I got my GED.
And are you able to read, write, and understand the English language?
Yes, ma'am.
And do you understand that you've been charged with the following offenses? 1 count of robbery, 1 count of aggravated assault, 1 count of influencing a witness, and another count of simple battery family violence.
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
And have you had enough time to speak with your attorneys about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
And do you need more time to discuss this case with your attorney? And are you satisfied with his services?
Yes, ma'am.
Counsels, are you satisfied your client has a full understanding of this proceeding?
I do.
And I do also.
And Mr. Easter, have you reviewed the indictment in this case?
Yes, ma'am.
And did you indicate your signature where it says defendant here?
Yes, ma'am.
And do you waive a form, or counsels, do you waive a formal reading of the indictment, including any and all defects in the indictment for purposes of this plea?
We'll waive it this time.
So wait.
And Mr. Easter, do you remember having been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No.
No.
And sir, you're entering a guilty plea to the following offenses. For robbery, the minimum is 1 year, the max is 20 years. For aggravated assault, the minimum is 3 years because it's family violence. The max is 20 years. For influencing a witness, the minimum is 1 year, the max is 5 years. And simple battery family violence is a misdemeanor, so the minimum is 1 day and the max is 12 months. Do you understand?
She has to take.
I understand.
Thank you. And I believe, Your Honor, we're attempting a negotiated plea.
I told you I'd take 15 surveys.
That's correct, Your Honor. So
We'll still just put it up, Judge, as we negotiated. We understand the court's position.
15 to serve 8 is what I'm gonna do.
Yes, sir.
Okay.
All right.
And sir, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I'm sorry, can you repeat that one more time, please?
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Do you understand what she said?
It's not, can you say it one more time?
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Do you understand if you violate probation, that they can resentence you? You understand that?
So it's a 12
They
to
can
8.
revoke.
They can revoke and resentence you. Do you understand that?
All right, so it's a 12 to 8, not a 20 to 5.
It's
It's a 15, I'm sorry, Judge. Could you repeat one more time?
15 to serve 8, balance probate.
That's what the sentence, the decision of the court is.
And quite frankly, the sentence ought to be 4 times that. Your lawyers have done a great job, and you ought to thank your lawyers for the great job. Because that video is one of the most appalling things I've seen in 30 years on the bench. So you need to look to your left, thank your lawyer, look to your right, thank your lawyer, because this is a gift. Okay, let's continue.
Sir, do you understand that if you place on probation, you cannot violate any laws or conditions, or the court can bring you back for a revocation, which means that you could spend additional time in custody?
Do you understand what she said?
And you throw in there, you're charged with intimidating the witness, and so is your father. You throw that in there, and that makes it even worse. All right, continue.
I'm sorry to ask you again. Could you repeat it one more time?
Sir, do you understand that if you are placed on probation, you have to follow the general and special conditions of probation, and that if you violate any laws or condition, the court could bring you back for a revocation, which means that you could spend additional time in custody? Do you understand?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Do you understand that? This is reported on your criminal history. Do you understand?
Yes.
Do you understand that if you were charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case? Do you understand?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else? Do you understand?
Can I have 2 seconds to talk to my lawyer real quick?
what? Just one more time, I was reading. One last, just read that last sentence to him one more time.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else? Do you understand?
You're a U.S. citizen, correct, Rahmene?
Yeah.
Okay, so this is not going to affect you. You understand that?
Yes, sir.
Okay.
And do you understand?
But wait, do you still have a question about your immigration rights? You're a citizen. You were born in the
I just wanted to like.
No, don't look at, you want to speak with us further? Is that what it is? I mean,
Please, Judge, can I
Yes, sir.
talk to them for like 2 minutes, please?
You may. Are we ready to continue?
Yes, sir.
Yes, Your Honor.
All right, please continue.
Yes, Your Honor. Sir, do you understand that neither the court nor nor your attorney nor the district attorney's office has anything to do with parole, and no one can guarantee parole no matter what anyone has told you? Do you understand?
Sorry. I mean, yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense. Do you understand? And do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Do you understand you're waiving those defenses if you were to go to trial, like she asked? Do you understand that? You're waiving any, can you repeat the question one more time, please?
Do you understand?
Please listen to what she's saying, so.
Sorry.
Go ahead.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? I'll say them to you one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told that they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial. Do you understand that you'll be waiving up those following rights I just named?
Yes.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading to these charges?
I do.
Sir, thank you. Sir, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
And we will just be speaking to a couple of things, not regarding, just put some things on the record regarding the charges and an offered plea on some of the charges, not all of them.
And as to some of the charges, Mr. Easter, are you pleading guilty because you have decided that it's in your best interest to do so under Alford?
Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and it places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment 25 SC 006407, how do you plead to count 1, robbery, count 2, aggravated assault, count 3, influencing a witness, and count 4, simple battery, family violence?
You got to answer the question.
How do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
I'm going to go over some of your appellate rights. Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Do you understand? Mr. Court Reporter, did you hear that?
Ma'am.
Get a little closer.
And sir, do you understand that the discretionary appeal procedure, which is outlined in OCGA section 5-6-35, must be completed within 30 days of today's date? Do you understand?
Yes, ma'am.
And do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
May I have permission to publish, Your Honor?
You may.
Your Honor, the court is very familiar with this particular case. and has seen the video. The state is going to go through a factual basis for this matter. Your Honor, this defendant on September 6, 2025, at approximately 11:59, at the MAA Centennial Park, which is located at 305 Centennial Olympic Park Drive, Northwest Atlanta, Georgia, 30313, within the confines of Fulton County, Georgia. Special Agent Sampson was contacted by that leasing agent to about a video that is timestamped at approximately 4 a.m. on the following or the prior day, which was September 5th, 2025. In the video, Special Agent Sampson, who is here and will make a brief statement for the court's consideration, observed a light-skinned Black female, later identified as Miss Jackson, wearing a black hoodie and colorful shorts, backing away from a male suspect, later identified as a defendant. They were having a verbal dispute. At one point, the defendant does grab the victim by her hoodie, and then he assaults her by punching her in the face, punching her in the stomach, punching her about the body, also stomping on her face and stomping towards her stomach area. It's the state's position from a statement that Ms. Jackson made, that Ms. Jackson indicated she was pregnant at the time. I understand that statement may be mitigated or minimized today, but she did make a statement to a victim advocate in our office that she was pregnant at the time of this incident, and later there was a termination of that pregnancy after this incident. Your Honor, the defendant was identified as Rahmene Easter. Special Agent Sampson was able to speak with Ms. Jackson and her mother. The victim did not call 911 for emergency assistance. However, the officers during the course of their investigation was able to locate an additional address for the defendant, which was 730 Glenwood Avenue, also in Fulton County. There they spoke with the leasing office, and the leasing agent was able to recognize the defendant as living in apartment 62 with another young lady who was identified as his girlfriend. And so at this particular time, the officer was able to get a search warrant for that unit 62. As part of the allegations in this particular case, the defendant is alleged to have taken the victim's keys, key fob, and her iPhone. All of those items were recovered from the defendant's home in apartment 62 at that Glenwood Avenue address. And additionally, the officers were able to locate another address for this particular defendant residing with his father that is in Fayette County. The officers were able to do a knock and announce and was able to make several loud verbal commands, and the defendant was able to come out and was taken into custody. If this case were to proceed to trial, the state would have presented evidence that there was a first assault that was captured at the 730 Glenwood Avenue address where the defendant reside. This is a 10-minute video, or sorry, a 10-second video. Permission to publish, Your Honor?
You may.
I thought we weren't publishing. Okay.
It is very difficult to see, Your Honor. However, it's the state's position that the person who's screaming, "Get off of me," is Ms. Jackson, and there's a struggle between the defendant and Ms. Jackson. Your Honor, has already observed the assault video number 2, and that video speaks for itself. There are injury photos from this incident where Ms. Jackson did sustain injuries to the bridge of her nose, also to her left eye, which is discoloration around her eyeball. This is the video from the second assault. The court has already seen it. Would the court like for me to replay it?
No, the court has vivid memories of this. Now,
And
the
I'll move.
fact that there was a prior assault is gasoline on this fire. And the fact that she was pregnant is gasoline on this fire. And do we know if this incident caused the termination of the pregnancy?
We do not know that, Your Honor.
But there were several blows to the stomach.
That's correct, Your Honor. And I won't play the jail call, but there is a jail call where the defendant calls Ms. Jackson and admits to each count in the indictment. Specifically, he states that he makes awareness that he knew that Ms. Jackson was pregnant. She also states that she was pregnant at the time. He also indicates that he did take her items and that he was going to eventually return it to her, which is the allegations alleged in count one.
Intimidation of witnesses by this defendant.
Absolutely, Your Honor. The defendant made statements directly to the victim and to his father, who was arrested and not yet indicted for influencing a witness. But in conjunction, the defendant did call Ms. Jackson, asking her to appear at first appearance to say that it was not a robbery, that this was all a mistake. And that is the basis of him contacting her and trying to get her to minimize this incident, and repeatedly asking her to testify untruthfully about the facts of the case, asking her to not testify that he did not rob her or hold her against her will.
What about the father's conduct?
Yes, Your Honor, the father is on a jail call as well with the defendant, and they are working in cahoots together. The father says, "I'll have it handled." And the state believes that he's referring to Ms. Jackson to make her unavailability as a witness and to ensure that she testifies untruthfully about this case.
What did the investigator want to tell me?
And make sure you put your name and put it on the record.
You can, yeah, right here.
Greetings, Your Honor. Throughout the course of this case, even for what I'm seeing here today, I do not believe that the defendant has learned his lesson. To me, the sentencing should be at the minimum 15 years because the defendant was pregnant at the time of the assault. Just based on what I'm seeing right here, him wanting to come out and back and speak with his lawyers, he thought he was going to get off, essentially.
Are you with APD?
No, sir. I was with Fulton County Sheriff's Office at the time of the incident.
Is that where you are now?
No, I'm with Homeland Security Investigations.
Thank you, sir.
Your Honor, we'll hear his criminal history, but I do think it's important to note that he does have a current warrant for his arrest out of Tennessee. That warrant is from November 20th of 2025. It's an extradition warning where he failed to appear on a felony identity theft, forgery, and criminal case. So once he is done with whatever custodial sentence in Fulton County, he will have to go to Tennessee to answer for those charges.
Did the victim want to say something?
She did want to make a statement. That's good. Okay.
Oh, she's outside. Oh, I'm sorry, come on up.
Ms. Jackson, you can come forward.
You can come forward over there to the corner where the sheriff is and state your name, please.
On this side or?
Which side?
Okay.
You gotta speak loud, stand right
Hi, good afternoon.
Please tell us your name
Naomi Jackson.
and what do you want to tell us?
That personally, I feel like the sentencing is kind of like outrageous because like y'all seen that small video, but that's not like how he is at all.
How did you, what happened to the pregnancy?
I was pregnant before the incident. I told
I understand that, but you terminated the pregnancy after this incident. Did this incident cause the termination?
No, I got an abortion before we got into an altercation. I told my mom that I was pregnant. I didn't like inform her when I actually went and got the procedure. So that's why when the situation first was presented, she said that I was pregnant at the time, but I wasn't anymore. And I said that there, but the officers at the time, they took my mom's word over mine.
Why do you think the sentence is outrageous?
Just simply because he's already been in jail for a year almost. And like I said, I've known him for 10 years. Like I know his kids, he knows my mom, I know his mom. Like we're kind of like family. So it just was a misunderstanding.
Are you excusing him brutally assaulting you as a misunderstanding?
Not at all. That's why I said in the beginning, I was like not really caring how the case went.
Mhm.
But as it has been going on, it's like he's been in jail for like 8 months now. I didn't think that it was gonna be that long, but like I said, I just feel like it's a little, it is a bit outrageous.
I will thank you for your opinion.
Can I just add one?
Yes.
One question? Has he ever put his hand on you before?
I need a full question, full answer.
I'm not ready, sorry.
To ask your
Okay.
question again.
Yes, you've known him for almost 10 years, correct?
Mhm.
Has he ever,
I'm
been-
sorry, you have to say yes or no.
I'm sorry, yes.
Has he ever been, have you ever seen him been violent to anybody at all?
No, never.
Has he ever been violent to you before? So this
Say
was,
yes or
No, no, I'm sorry, no.
was this an isolated incident in your mind? And-
Honestly. Gotta speak. Yes, honestly, I'm sorry.
Okay, she's doing the best she can. So that, could you answer one more time, please?
Yes, honestly.
Okay, so, that's all I have, Judge. I just wanted to point out that.
Oh, well, thank you for your opinion.
Judge, well, I do have just two more questions.
Yeah,
Madam, did y'all ever live together?
Not like permanently. I was like, we've obviously spent extensive times with each other, but not like living together, no.
No, y'all never resided together?
No.
Okay. The second thing is, who was the lawful owner of the iPhone 15 Pro Max?
It was his phone because my phone was broken at the time.
Okay. And when you and I had spoken before, you said that in the indictment, it talks about the phone being taken, the car keys and the garage fob. Were those,
There was no fob.
is that something that
Your
would,
Honor, relevance?
okay, well, it's just because we're going to tender an offered plea on those cases.
I'm accepting the offer plea. Sir, do you understand the nature of the charges against you?
Yes, ma'am.
You understand all the rights you give up?
Yes, sir.
And you're giving up all those rights freely and voluntarily?
Yes, sir.
Counsel, you satisfied that your client is competent, understanding the plea is voluntary and there is a factual basis?
Yes, I am, and yes, I do.
I find the defendant's competent in the plea. I find the plea is voluntary. I will accept the offer plea and sentence for a total of 15 years to serve 8 in custody, balance probated, no further contact with the victim. What is his credit date?
September the 5th, 2025.
All right, that'll be his credit date. And the defendant's remanded to the custody of the Georgia Department of Corrections to begin serving his sentence. This,
Be open to adding family violence intervention program?
yes, absolutely. This court's in adjournment.